Allie, can you hear me?
Yeah, I can hear you. How are you, Rev Whitaker?
Okay, can you see me?
Yeah, I can see you too. How are you?
Oh, okay. It's nice to not be a ghost.
That is always a good thing.
Hi, Haley.
Morning, Lisa. How are you?
Good morning. I'm doing great, thanks. I'm gonna be listening to your board meeting today.
Wonderful. We're gonna have a good meeting.
Okay. Betsy may not be able to join. She has several meetings, conflicting meetings.
That's what I heard. She's a busy woman.
Mm-hmm.
Good morning, everybody. It's Dr. Patrick Canavan. I want to welcome everyone. I think I see that we have 6 members present. And I don't know if we're waiting for any others. Hallie, would you go?
Patrick, I think we're only missing Emily and Katya, but I haven't heard otherwise from them.
Okay. So why don't we go ahead and at least get started? We have a quorum, so I think it's okay to do that. So again, welcome everyone. Good morning. Thank you for being here. I'm Dr. Patrick Canavan, the chair of the Clemency Board. Today is May 7th. It's 10:35 a.m. And we're holding this public board meeting. Our agenda today chiefly centers around rulemaking again. We've had quite a process going and lots of input. Our friends I see, 2 professors from Howard University Law School, Professor Moyd and Professor Ross, welcome. Thank you again for your work. It certainly shaped our thinking in many ways, and we appreciate that. What we're hoping to do today is get just an update on where we are with rulemaking. The draft was sent to members this morning for review. The rulemaking committee has continued to meet often in the interim periods between these public meetings. And I think we're want to hear from the rulemaking group today as we continue to move forward on these issues. So with that, why don't we start off with update from the Office of the General Counsel. Haley?
Yeah, thank you, Mr. Chairman. Happy to just provide a quick update on technology. So we were able to launch the Clemency Board's email account this past week. So it's clemency@dc.gov. So that is up and running. The website is in the process of being built, and we're hopeful that it should be live by June. So good progress on the technology front.
And you said we think the website will be up by June?
That's the hope, yeah. I'm meeting with the technology team next Tuesday to check on their progress.
Okay, that's great. That's good news on both of those fronts. Because our agenda was sent out a couple of weeks ago, I wanted to make a motion to add an agenda item, which is an update from the rulemaking group. Can I get a second for that motion? See Reverend Whitaker indicate. Okay, so I see two.
I'm trying.
All right.
I'll second the motion.
Okay, you got a second now. All those in favor, you just indicate by saying yes.
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 Okay, great. Thank you so much. So let me just run through generally. I'm going to ask Haley to talk a little bit more specifically about some of the issues that were raised through the rulemaking committee. We met most recently last Monday to review a draft of the Clemency Board regulations. So the regulations largely mirror the Clemency Act and covers topics like the conduct of meetings, applications for letters of recommendation, reporting about board decisions, the applications, and the OGC's support of our work. On April 1st, a group of us met with the U.S. Pardon Attorney and reviewed with them ways that would be most helpful for us to facilitate clemency and pardon applications being reviewed by them. It was a very productive meeting. We're really, really grateful for the U.S. Pardon Attorney herself to meet with us for more than an hour, and for the senior administrator in that office doing so as well. It was a really productive meeting. Really grateful for that. What we learned there was if we use sort of the same format that they use in their recommendations, we will expedite the process for people, and it's a good way for us to organize our work as well. So given that, the regulations as drafted currently are written to give the board discretion to consider a range of criteria and priorities, including, of course, the mayor's priorities, presidential initiatives, and guidance issued by the Department of Justice. And it's important that we're able to do that in a flexible sort of way, as those things may change over time, and we want to be aware and able to adjust to those things. So that that discretion of the board is an important thing, and that was a priority in development of the rules. The rulemaking committee approved that draft regulation with edits, and those edits that were asked for on Monday have been made by the OGC, and that is the version that was circulated to members today. So just a little bit about the process. We're going to ask to accept this rulemaking today after we do a brief review of it, and board members have opportunity to ask questions and things. But going forward, the regulations will be reviewed internally, and they may change after receiving feedback before being published for 30 days of public comment. That is the normal process for rules, for regulations as presented by the EOM. So it's an internal process there. So there may be some more changes before they are published, but we believe those changes will be, consistent with the guidance we've already set forward. Then they do get published for 30 days for public comment, and it's at that point that we will be welcoming public comment on them, and maybe trying to seek out public comment from a wide number of areas related to those. So with that, I would ask, Haley, do you want to review? We had talked about 2 or 3 areas that we thought were most important to review, and then just a general highlight of the regulations.
Yeah, I'm happy to. Let me share my screen. Let's see. All right. Okay. I think you should be able to see my screen. So just a review of the regulations as written. So right now, this is the table of contents. So it covers the purpose of the Clemency Act, the membership, and those two sections are largely drawn from the Clemency Act. The notice of the meetings, that a lot of that is compliance with the Open Meetings Act. Conduct of the meetings, applications for letters of recommendation, which I'll go over. Legal advice, which just talks about the board is not going to be representing any applicants before the Department of Justice or forming any attorney-client relationships. Reporting requirements, these are the report requirements as outlined in the Clemency Act and what we're planning to submit to the public on our work. Administration just talks about the Office of the General Counsel's support of the board's work. We have some definitions as well. So I'll talk about, I think, probably the most interesting section and highlight the application section. Christina, who you all know, talks about this section and a lot of our regulations as being a house or a frame for a house, which I think is just the perfect metaphor that I keep coming back to. So when you look at this, as you know, Dr. Canavan said, this is gives the board discretion to be flexible and adapt to changing circumstances. So this section talks about how the application is going to be issued by the board, and it's separate from the application actually for the pardon or commutation through DOJ. So the applications submitted to us are, you know, we're trying to be very clear, they're for letters of recommendation. And the board may issue these letters for eligible individuals who've been convicted of violations of DC code. And importantly, as Dr. Canavan mentioned, we had a great meeting with the pardon attorney, and they gave us the encouraging news that we could not just recommend new applicants, but we could recommend people that have already applied. So that's awesome, because I'm sure there's a lot of people, you know, who might want to take advantage of this process to get a letter of recommendation, but maybe have already applied. So that's awesome news. So we just talk about a little process here. They're issued in the sole discretion of the board, and then they'll be given to the mayor, and then the mayor is going to send them to DOJ. So in the spirit of access, and I'll pause for questions at the end, but I'll kind of give high level. In the spirit of access, we are accepting applications both through our website and through paper. So if anybody wants to mail them, they can mail them to this address. This section talks about this is a little bit of process that just talks about what's going to happen when that application first comes in. So our office is going to conduct a preliminary review to make sure that they're eligible under the Clemency Act. So we're going to look to see if they're missing any required documentation. So if an applicant is missing something, we're going to give them the chance to correct it. And we did put in a provision that's going to allow us to close out their application if we provide them 2 notices and they don't respond within 3 months. And we are going to tell them, you know, that they can reapply anytime, but they would need the missing component that they were missing. If they're not eligible for whatever reason under the Clemency Act, we're also going to send them a letter saying, this is the reason you're not eligible, and you can reapply if you do become eligible. Finally, if the application is complete, the board will make a recommendation. So this is a section I want to highlight for the board that we inserted after re-reviewing the Clemency Act this week one final time. So the Clemency Act does have a time deadline on the board. So the board has 6 months to decide whether to recommend an applicant to the President of the United States. Importantly, we also feel that the board can make the decision to defer an application for a reason, and that would be in compliance with the 6-month deadline. So we just need to make some decision and communicate it to the applicant within 6 months, but we wanted to highlight that in the regulations. All right, I'm going to keep cruising. So this is an important part of that frame of the house, that the board has discretion, as Dr. Canavan said, to use different criteria to evaluate applications. This is something that will be considered. So the Department of Justice's Justice Manual, policy, priorities of DOJ, initiatives by different groups, interested institutions. And we also talk about this in this paragraph. This is, another part of that house is that the board can review applications out of the order they're received, meaning that if the president issued an initiative that we thought was really important to focus on and wanted to focus on maybe a particular type of offense or crime or type of individual, we could also take advantage of that initiative and prioritize review of those applications. So that is most of that section. In this section, we talk about that the board has the ability to hold hearings and get facts and invite witnesses. Under the Clemency Act, we reiterated that if a hearing is held, people will have access to their own attorney or non-attorney representative, and that the board itself will not provide counsel to applicants. So the actual vote itself, the board will decide to grant or deny by a majority vote of those present and voting. This 0.6 section also talks about if people have, if board members have conflicts of interest that, require them to recuse themselves, we will ask them to do that. And that's consistent, with all their professional obligations, conflict of interest rules, and bar association standards. 0.7 is the work product that the board is going to be putting out. So it talks about that the board is going to write a letter of recommendation, and it can ask OGC to help it in drafting the letters. Once the board has approved it, it can delegate that ability, and it doesn't need to review it before, it doesn't need to review each letter. And then finally, applicants will have notice of their final decisions. Applicants don't have the right to appeal to a higher, like intermediary body. The board's decisions are final, but they do have the ability to reapply, and we put in 2 years from the date of any denial. So I know that that's the biggest section, that's the most new material. I'm happy to answer any questions on that section, as well as review other sections that are of interest to the board.
Thank you, Haley. So I'd like to ask the board members if there are specific things you wanted to see directly and have a discussion of today. Please feel free at this point. Anyone with any questions on the board? Okay, very good. Well, again, thank you, Haley, for that.
Hey, Bill,
Oh, I'm sorry.
I did have a question, and when Haley was reading that, I didn't mark where she said it, but I think it was something about the whoever has a chance to reapply to us. Well, since we're just starting, nobody's reapplying. But I'm guessing they applied to the federal clemency board or something like that. Is that what it was saying, Kelly? I wish I could have stopped you or would have stopped you. I can't remember where you said it.
No, that's okay. Yeah, that's an awesome question. And I think it's something that's kind of unique in our process is there's 2 parallel applications going on. People are applying through DOJ and they're also applying for us for the letter of recommendation. So the section about reapplying was relating to just our letter of recommendation process. So if somebody applies to us and we decide not to write them a letter of recommendation, we will allow them to reapply for a letter of recommendation from 2 years from now. But at any time, they always have that right to go straight to DOJ and do their own, process or application. And we can either help them as they apply at the very beginning of their process, or if they've already applied, we can supplement. Does that answer your question?
Yeah, I'm wondering because when I was going around the nation, some of the inmates in the facilities they were in were allowed to apply for clemency with the BOP, but being a DC resident, I don't know how that worked out for them. I don't know if, but some of them had their cases heard through the federal. Would they be able to like say if they had applied through the BOP and had about a year left, would they still have to wait another year to apply to us?
So, I think as I'm understanding your question, you're just asking if there's like any delays and them applying for us for their letter of recommendation. And the only thing that would stop them is making sure they're eligible under the Clemency Act. And then also, if they had already been denied a letter of recommendation, they'd have to wait 2 years. But that was only if they had already gone through our whole process. And you're right, we haven't processed anybody, so nobody's been denied yet.
Oh, okay, because I didn't want it to get confused with the BOP and us.
Yeah,
Because I don't
that's
think
an
it's the same thing. It's like you said, two things running at the same time.
yeah. I think that's such an awesome point, Reverend Whitaker, and I'm actually hoping to someday create maybe an infographic for our website, which talks about here's our process and you what you get at the end, and then here's DOJ's process. Because I think it is a little tricky what the board's trying to do here, and I want to make sure we're clearly communicating it to the applicants that they're applying for a letter of recommendation.
Okay. All right, thank you.
You're
Reverend,
welcome.
anything else you wanted to raise?
No, not at this time, Pat. I think that was it.
Okay. Yeah, I would say, you know, the clarification that we got with the Office of the Pardon Attorney was helpful in that our recommendation, if it's in the format that they are able to digest easily, will be, you know, readily reviewed and in support. So we're trying to make our recommendation as easy for them to use as possible, still advancing the goals of the district, the mayor, this body, and, you know, the rights of residents of the District of Columbia. So it is really important that we help people understand the recommendation that we do is different from the DOJ application for pardon, but that we want it to be as consistent as possible. We don't want to impose any sort of untoward hurdles on people while that's going on.
Okay.
I think Christina wanted to jump in.
Oh,
Real
I'm
quick.
sorry,
I'm
please.
gonna unmute you, Christina. Okay, Christina, you're unmuted.
Good morning, everyone. Apologies if you can't hear me very well. I just wanted to interject about Reverend Whitaker's question. Reverend Whitaker, anytime that the DOJ has a pending application, in our conversation with the pardon attorney, they informed us that we would have every opportunity to supplement their applications with a letter of recommendation. So given the life of review in the pardons office, if there's still a pending application, we will have an opportunity to supplement that. I hope that resolves your question.
Okay. It does.
Okay, any other questions from the board about where we are with the regulations at this point? Going once, twice. Okay, very good. Haley and Christina, correct me, we don't need to vote on anything at this point on this? It's in the process at this point?
I think our hope was to get the full board's recommendation for today, if possible. I know the rulemaking committee did approve it Monday.
Okay, sorry. So if someone wanted to, some board member wanted to make a motion to approve moving forward with regulations as they've been presented today.
Well, I'll make a motion to move forward with the regulations that were presented today. Pending any, I know Monday we talked about any corrections or additions. Pending any additional corrections, yes, we can move forward. I mean, I'm making that motion.
Great. Is there a second? Thank you. We got a second. All those in favor indicate by saying aye or raising your hand.
Aye.
Aye.
Okay. That seems unanimous. I know that the U.S. Attorney's Office has abstained from that. I appreciate the clarification that I understood the other day from Attorney Suttenberg, which is the U.S. pardon attorney is the one who speaks for the Department of Justice on matters of an application. then the U.S. Attorney participates in this as a matter of policy in order to help us have a full understanding of the district circumstances, but will not vote on particular cases. So thank you for that.
Patrick.
So I think that was unanimous minus U.S. Attorney abstaining. So we'll go ahead and do that. Okay, so now's the opportunity for some public comment, and I note that we do have some members of the public here from Howard University. So if there's anyone in the public who want to make a comment, we'd be happy to hear it now. Oh, Professor Moyd, I saw your hand first.
Good morning, everyone. It's great to see you all again. I know that my colleague, Professor Ross, is also on the call today. I want to make just one brief comment, and then I have two questions I'd like to ask. The comment is, I just wanted to let you all know that the Council for Court Excellence has held a series of teach-ins throughout the district over the last several months. And we did one specifically on clemency. And I just wanted you all to know that there were a lot of questions about the Clemency Board. As we talk with the community, there's just a lot of interest in knowing what you all are doing and when the actual applications will be available to folks who will be eligible to apply. So I just wanted you all to know that. But I do have two questions about the review. Thank you so much. I'm not going to butcher your last name, so I'll just call you Miss Haley. Thank you so much for going over the work that the committee has done. So my first question has to do with, you indicated that 2 notices would go out after a person applies, 2 notices will go out. And then if you had not heard from the person in 3 months, then I guess the application process would be closed. My question is, has there been any thought given to individuals who might be in BOP and transferred from one place to another? Just wondering how you all landed on 3 months and whether for folks who might not have any control over their transit and transportation, whether 3 months is sufficient. So that's my first question. My second question is, you indicated that the board would not provide attorneys to applicants. And I just wonder if there was a discussion about working with the DC Bar or some other organization, the Washington Lawyers Committee. Has there been any outreach to try to, have the bar step up and represent some of these folks when applications can be submitted? So those are my 2 questions.
Thank you, Professor Moyd. So wonderful to see you today. So Christina is she jumped in and said she'll take the first question, and I'm happy to take the second, which is about outreach. So Christina, you can unmute yourself and jump in.
Good morning, Professor Moyd. Thank you so much for that question. Yes, we're certainly aware that different applicants will be at different times moved if they're through the BOP. And for those reasons, we picked 3 months in order to be able to give us that time to be able to reach them, locate them, and provide them the adequate notice that they need for their applications. And part of what we're also trying to decide is, in receiving those applications, that we are also in communication with them about their current status of their cases. And part of providing notice means to actually, reach them and acquire them. And legally, what we'll do our due diligence on our end. The regs don't go into specificity about how we go about doing providing that notice. And that is something we're going to be able to draft in our internal operating procedures as we frame out the process. But as Haley indicated, the regs right now are just building up the structure for the Clemency Board. And we certainly have taken full consideration of the fact that various applicants will be moved during the life of their application.
I think Professor Moyd raises a really good point about, because it's not just communicating back by the applicant, it's providing the required information. And the BOP process of moving individuals does take a really long time. People normally go through a transportation, they go through an intermediary, one or more intermediate placements before they go to their next placement. And often you will try to reach a client in one placement and it's impossible because they've moved on to the next placement. And sometimes the BOP website isn't accurate or updated in real time as to individuals' locations. So I would share that concern if we could reopen on that issue, because it is really, it's providing the information and it is within a 3-month time period. And I think definitely individuals have been in transit even during non-COVID times for more than 3 months. And it is when you're sort of in an in-transit placement that you're particularly susceptible to not receiving information.
Yeah, and I think these are both excellent points, and this is the rich value of your expertise that you bring to these discussions. Professor Moyd and Katya, do you have a sense of what a better or more reasonable timeline would be? I view this as a pretty minor change. So, the board approved, the big regulations, but I view this as like a pretty minor change that we definitely could and should consider. So, given your expertise, is there a more reasonable time frame that you think would be fair?
So my recommendation would probably be 6 months. Katya is certainly correct that it happens very often that a client gets transferred and you try to find your client on the BOP website and it shows in transit for quite a while. And when clients are not in the BOP but in a state-held facility, it's also hard to find them, and it may take a while. So my recommendation would probably be something like 6 months.
And let me just add, because when I was inspecting the prisons, I remember it took one of our inmates 18 months for his teeth to catch up with him. 18 months. And he's been to 4 facilities and they were following him around. And this is the BOP, this isn't even us. They couldn't even track him. And they finally caught him in Texas when I found him. Because of our intervention, he finally got his teeth, but that was 18 months later. So it does take a while. So I believe in 6 months may be stretching it, trying to find him, but it's better than 3 months. So I gotta agree with that.
Maybe it's two things. Maybe it's saying within 6 months, but also not just providing all the required information, because if the individual just gets to the facility, they're not going to be able to find all the information. So it's really communicating a response, right? I'm still looking for this. If it's something from the case file, they have to be able to contact the Court of Appeals and try to get something. Or, I think we tried to make those things more flexible when we were talking about the other guidelines. But there's the other point of rigidity, which is the providing that information. And maybe it is just like communicating an intent to proceed by attempting to complete the application.
I think that's a great edit, and I think it captures the concern we are trying to address in that paragraph is if we're not reaching people, and you're right. I think the concern was non-responsiveness rather than people diligently trying to supplement their application. The other thing I'll add, even if we do, and I'll follow up on this with our team, consider the 6-month timeline, and if that is kind of the consensus of the board, it is a May. The office may close applications after 6 months of non-responsiveness. So if it's the practice of the board to be more generous than that, they can be more generous than that. But it's a right of the board in the interest of efficiency or of keeping our process flowing that if they choose to enforce that, they could.
I would say the board needs to start with 6 months, and as it goes on, if it changes, it will change, but 6 months will be a good start.
I just want to clarify that this 6 months is prior to the application being deemed complete. And so the board's timeline has not kicked in either of having to act within 6 months, right? This is all pre that deadline. Because what I get, for administrative purposes, I get worried that we're not able to achieve our mission, which is to address these completed applications within 6 months. But that change will not have any impact on it. So I support that change.
And what if the applicant fails to respond to communication regarding required information? Instead of provide, applicant fails to respond to communication.
Meaning that they say, I'm still interested, but
I'm looking for it. I can't find it. Like I can't
Yeah.
get a vote. I can't get a copy. I can't get mail out of the Bureau of Prisons. Like all the realities that individuals face who are incarcerated.
I am looking to be as broad as possible pre-application completion to allow people to get things in. I think all of us have expressed, I mean, most of you have expressed that to me directly at some point or other, that before the application is deemed complete, we should try to do as much as we can to allow people to actually get to the point of application. So I also think that that's a decent change as well. My concern as the chair of the board is not to be a tardy board that, we don't meet our own required 6 months to act on a complete application. This has no bearing on that. So again, I would like it to be as open as possible. And that change, I think, allows for that.
And this is Ilana. This is a slightly parallel point, but the Office of Pardon Attorney's website has kind of a case tracker where you can input a defendant's name, register number, etc., and track the status of the application. This might be an IT lift that I don't know what capacity the mayor's office has, whether there could be a similar function in the DC version that could alert someone, both the individual and the community, as to what the status of that is in the DC Clemency Board.
At the very least, provide a link to that from our website.
Sure.
To, a link right to the DOJ pardon attorney.
Sure.
Great.
Does this, would this edit and capture your concerns, Professor Moyd and Katya? Do you think this is kind of what you were thinking?
Yes, absolutely. Thank you.
You're welcome. It's a wonderful point that started a good discussion, so thank you.
Mm-hmm.
I think, have we reached, I think we're good on this one. I'll jump to addressing your second point, which is outreach. So that's a fantastic question. I'll share that, like, as we were drafting this and thinking about this, we were always very cautious about, it may not be in the interest of people who are applying for a letter of recommendation to grant everyone a right to an attorney. If they are, if we have so few attorneys, or a right to an attorney provided by our office, let me say, when we clear that up. In that case, it might slow down the process so much that, it might not be in their interest. So we're giving them the right to bring their own, always, always. And I think you're right. Our hope is that everybody always would have appropriate and competent representation anytime they came before this board. So I think that's an important next steps on our to-do list is to build those relationships and build that capacity in the field so that individuals, if they do come before the board for a hearing, have the best possible chance to get a letter of recommendation and to present their case. So I think that was a great flag for you to raise. I'm going to add it to my to-do list as something that the board could think about is building that outreach committee.
Thank you.
Haley, can you hear me? It's
Hi,
Felisa.
How are you, Felisa?
All right. So I'm a little bit confused as to when the notice starts tolling for the board to consider an application, well, I guess consider application complete, and when we have to, make our final decision whether or not we're going to recommend, and what the professor what Professor Moy just brought up and you guys just discussed, going back to the previous question. So I'm not seeing where the two, the notice process for communication versus the board's obligation to have a decision within 6 months. I'm not seeing how those two timelines, I guess, align. Because okay, you're talking about which the professor, like the professors and Kati, Katya, like brought to our attention. I don't see how those two things align. So like in my mind, it was hard set. We have to have a decision within 6 months. I don't know when that starts to toll versus incomplete application and when things start tolling for that process. So maybe I need a infographic for that, because I thought in my mind it was hard set. We had to have a decision, but I'm not seeing when the clock starts tolling for the board to make a decision about whether or not it recommends versus incomplete application. I guess that's something I've always been stuck on.
Yeah.
Right. So the basic point here is we have, once the application is deemed complete, then we have 6 months. But
Yeah.
The issue of, kicking an application at 3 months is what we were just discussing. We've changed that now to 6 months. And it's still May, meaning it doesn't have to happen. But we've doubled the time period in which an application can be completed, and giving the applicant an opportunity to say whether they're still would like to pursue this or not just provide information, but that they still would like their application to remain active. So we've expanded that. That's all pre-application. Once it's deemed complete, then is when our 6 month toll starts.
Okay, so I guess there'll be an administrative process of like, okay, this application is complete. So
Start the clock.
We'll have to like I guess I don't know if that'll require a notice component to it too. It's like this application is complete, therefore we're start tolling the process. I guess that turn on the clock, but I guess the incomplete application is another, I guess, process and deadline. Okay.
Mhm.
Okay, thanks.
Any other questions? Yeah, we're still in the public comment section. Sorry, Professor Ross?
Yes, well, thank you. Well, first of all, thank you for getting something done. I was starting to worry, and I really like this flexibility that you included. I think that makes a lot of sense. And I have mostly a lot of questions because I don't completely understand it conceptually. Essentially, what I understand is that what's going to happen is there's a letter, and then that letter will be sent to the DOJ. So I'm wondering, how does this really add anything for DC residents? Does the person still have to, the applicant that is, still have to fill out the DOJ application also? What is the DOJ promising? I think this is maybe where you started about, are they basically going to agree with what is recommended, and then it will go from the DOJ directly to the president? So that's sort of how it works. The other question I have is about the hearing process, right? So it sounds like you decided not to have a hearing with witnesses, and you are going to decide it based on the paperwork, which is totally your prerogative. I just wondered, did I understand that right? Because if we're going to be explaining it later to the community or whatever, once it's out, the more we know, the better. And the other question I have is, as you know, when Professor Moyd and I, our students presented, we really saw the rules being different between whether somebody is seeking commutation or a full pardon. And so for commutation, that seemed to us to be the #1 important issue. People who are locked up now, as opposed to the pardon where they're out and it's like 3 years later or something. So what I heard today from the discussion is that you also are really focused on commutation and people that are in now. And I didn't really hear anything about pardon. And I wonder if that's just something for another day and another set of regulations. Along with that, what something else that we thought was really important is that if somebody is coming to you and saying, I'm innocent, that's a really, really different kind of claim than, look, I've been in way too long, you know, please take a look at my record, et cetera. I should be getting out and I've rehabilitated. Those are really two different things. And so we wanted people not to accidentally fill out paperwork that hurt them. And so that was an issue in terms of how are you going to be filling, you know, what are these applications going to look like? Are they going to be clear that if you have actual innocence, go talk to a lawyer and go that route? Because I don't think that you as a board can really filter out an innocence claim without having a lawyer representing that person and coming in. And otherwise, they're probably just ruining their case from here on in. So that was something else that I didn't hear addressed at all, but and struck me as kind of an issue. And are there going to be applications is the application itself something that has not been written yet? And will there be a chance for us to comment on it before you all vote on it? I think that's it.
Okay, so I'm going to start. I am, full disclosure, I am not a lawyer, okay? So I hear the Hallelujah chorus going off in the background right now for that fact. But let me just tell you, the pardon attorney was very clear with us that they welcome the recommendation of the Clemency Board on behalf of the mayor. They are very interested in us, but they have their process, and their process will govern moving forward. We augment that process, and they really indicated to us that they think this is a, if we do it well, which we intend to, that this will be a strong voice that is listened to. But they can make no guarantees, you know, given their priorities and all that sort of stuff. Nonetheless, this is the right thing for us to do, is to strongly advocate by sending serious letters of recommendation. That's our intention. So that's kind of where we are with the pardon aspect of this. In terms of hearing, what we've done in the regulations is give ourselves wide ability to hold a hearing or not. So what we've really done is just protect the ability to do that based on the circumstances of a particular thing. Our intention, you know, is to gather all the information we can, and if that requires a hearing, that we would do that as well. So I think you're right about the currently locked up people seeking commutation, that they are a priority for us. But also what we've preserved in the regulations as we've written them right now is the prerogative that, you know, if we go through the commutations, you know, the bulk of those quickly, and there's a new thing that we need to be doing, that we have the ability to pivot to that as well. But I don't think that anything in the regulations really does prioritize commutation over pardon. It sort of treats them as equals, but the board has the ability and the discretion to determine these are the most important things to us to follow. And, you know, my way of operating has always been that, you know, community input into those determinations and those policy priorities are important. We'll listen to the mayor, we'll listen to the president, we'll listen to the community. So what we've done is preserved our rights to be able to make those determinations as things come along. On the innocence claims, I'm not a lawyer, so I'm not going to comment on that at all. I know there was some discussion. I don't recall the specifics of that. So if there's somebody from the rulemaking committee that wants to comment on that, I'm happy to have someone else do that.
What I will say, Professor Ross, first of all, thank you for these wonderful questions and your thought. We're so lucky to have your input. On the actual innocence claims and as they relate to the unique issues they might present in an application, I'll answer your fifth question by jumping back to the fourth. The application is not written yet or published. So that's part of the regulations is that the board may issue the application and may update it. The regulations, are really this house, and then the board will continue to build out, the framework of what that looks like. I think Dr. Canavan jump in here, but I think a thought would be for the board to consider the application and then present it in public comment, a draft for the input of the community. And that would allow for, if you had expertise around the actual innocence guidance or whether you'd want to include some additional information, I think that'd be helpful. I will share that the pardon attorney did talk about, they have their own applications and there's two of them. They have one for pardons and one for commutations. And I think our sense was that it could be in the interest of the DC community to utilize their application to prevent, people from having to redo two burdensome processes or complete multiple sets of the same information. And then the clemency board would have the opportunity to create a supplement that that includes and emphasizes the values that DC wants to address or supplement. But perhaps the DOJ application could serve as a base just to prevent, extra administrative headwork or, headache and whatnot. And then also having them complete the DOJ application. The DOJ also said we'd have the ability to submit on other people's behalf. So if they wanted us to, we can make the decision on the letter of recommendation and then submit that letter right on top in the actual application. And that reduces, administrative burden on our community. So happy to answer any additional questions that you might have.
So when we looked at the DOJ application, it was very, very difficult for somebody to do pro se and to fill out, and it was a barrier. I think it's one of the reasons we're doing so poorly in DC with DC code prisoners getting out. So it doesn't seem that they should have to fill out that DOJ application before they get to you. They should be filling out something that's a little bit easier. And then are you suggesting that maybe you could help them fill out the DOJ application along with the letter once you've approved them? Because that seems to make a lot more sense, and you'll have a lot more success if you do it that way.
So I don't want to jump out in front of the board. So this is something very much, that would come as a next step after the regulations. And I think you're right, gosh, that DOJ application is long and is burdensome. But I guess something that we were considering is that, listen, until the mayor becomes a governor, DOJ is going to hold an important role and the president is going to hold an important role. And ultimately, that application is going to need to fill out somehow or some way for them to actually be considered for a pardon or commutation. So at some point that needs to be filled out. I think one strategy the board could utilize is to build a lot of robust partnerships and clinics, with the law schools like Howard, Georgetown, GW, to create spaces to have people apply for, both their letter of recommendation and their full pardon or commutation one day. They just sit down and do it together. But I think it's an important discussion the board will have to have at an upcoming meeting.
Thank you.
Yeah, I appreciate you also bringing that up. Somebody said, should there be an appointed subcommittee on community outreach? That's something I want to talk to the board about and start to think about how do we start to look at our role, as the clemency board itself and what's entailed with that mission, and how can we best serve those who are coming before us for a determination on a recommendation, and what supports might there be available to them, whether that's something the board does itself or whether we work with partners to have that happen. I think we have to address that soon.
Pat, and I might be jumping ahead, but as far as these forms and applications, and this may be part of your outreach also, we can probably partnership with someone and have them go into the facilities and do a application training class for the inmates. And if they would, put it out there, the inmates would come to the class. Because when I was at DC jail as supervisory chaplain, we used to do that. If they wanted banking classes, we would have bankers come in to teach them how to do their finances. And the inmates would sign up, they would come in, and that might help. But that's something we could talk about later.
Yeah.
because it's a long
So,
time.
no, but I appreciate that, and I'll take that as you're volunteering to be a member of a community, a future community outreach committee. So thank you very much, Reverend. No, but I actually think it's those kind of creative things that we need to create some process around, understand what our proper role is in that, and then see what we can do to coalesce others to jump in with us. So I think that's awesome.
I don't read the regs as requiring the DOJ application to be submitted prior to the submission of the Clemency Board application. Is that Professor Ross, do you read it differently, or is it just that it's ambiguous?
I read it exactly the way you do. In fact, what we recommended is that people not have to do the DOJ recommendation. But the reason that that is not happening, it sounds like, is because the pardon attorney would like that. So then
I think it's in the, oh, go ahead.
No, that's fine. You got it.
My memory was that it was in the federal regs, that it has to go through that they have to do that application from the federal regs in order to make the petition for the pardon. But do you read that there's an ambiguity in these regs, that it makes individuals believe that they have to do that first before they do the DC application? Because I think you raise an excellent point that this application can be leveraged to provide individuals with assistance in the sort of subsequent application that has to happen.
Exactly.
Okay.
Mm.
Okay. Any other comments, anything else that the board wants to say at this point? Okay. So what I would suggest is, number one, I was hoping that we could schedule a board meeting sometime, I'm thinking mid-July. And what I'm hoping that we would have there is that the regs would be significantly through a process where we've heard comments back and the board can start to address some of those comments. Maybe at that point, maybe we're at the point where we could review a draft application. Maybe we could see a demonstration of a website, and perhaps we could have a robust conversation about our role in community outreach or in helping have supports. That's a pretty ambitious agenda, but I think Professor Ross's editorial comment about her fears, certainly all of us feel pressure to make sure that justice and that mercy is being dispensed here. So we all feel that same sense of urgency around this. So I'm looking at July 16th, and I'm just going to see with the board if anybody has an absolute no for July 16th as the next board meeting. It would be at 10:30 in the morning for an hour and a half. Okay, see, Andrew, it's good.
No objection from Felisa.
I'm good, Pat. I'm good.
Thank you. Katia, Emily, Elena?
Good for me, Ilana.
Good for Emily as well.
Sonia?
Yeah, that's fine. Katya.
It's good for me as well.
Awesome. So let's plan on July 16th, 10:30 a.m. So is there a motion to adjourn?
So move, Pat. I'll make a motion to adjourn.
Second? Second, anybody? Andrew seconded?
Second.
All those in favor?
Aye.
Great.
Aye.
Thank you, everybody.
Aye.
Appreciate your time. Thank you so much. Bye now.
Thank you. Thank you, Pat. Thank you, Haley. Thank you, everybody.
Thank you.